slightly different because Jamil Mukuru is charged under the International Crimes Division Act, which is a manifestation of the Rome Statute, which has a different jurisdiction. This is dealing with genocide and different things. So when you say that Jamil Mukuru was being tried in that, it was being tried there because of Section 9 of that particular act. Now, that act that we brought in, Section 7, 8, and 9 deal with genocide, crimes against humanity, and war crimes. And that is specifically derived from the Rome Statute. So that is the explanation why. So when we entered the Rome Statute, we agreed that if a person commits such kinds of offenses, they will be tried in a court which has structures and jurisdictions which are different, or which are similar to the Hague, to the ICC. And that one has pre-trial chamber. It has a different procedure, totally different from our criminal justice system. Honorable Chair, now I think what Honorable Katuntu said is important, that we will need to come here, and I've tried to, we are working on pointing you to the specific pages, but it's going to require that every member takes time on their own to look at the judgment. But we are going to we are preparing a guide. I had started on it last evening, but I wasn't able to finish. A guide on the pages and what was said by every court. And I can state, honorable colleagues and members, without any fear of contradiction, that the court did not, the Supreme Court did not at any one point say civilians cannot be tried in the general court martial. I want to state that as without fear of contradiction. The Supreme Court did not say that civilians cannot be tried in the court martial. Like Honorable Katuntu said, different judges went through it in different ways and arrived at this different conclusion, to the conclusion that the court martial as it were constituted, and the way it had been set up in the law was not constitutionally set up to try civilians. And on the issue of the offenses, they said they were vague. So, colleagues, it is important that we all really get an understanding and an agreement on what the Supreme Court said. And I have got some of the pages here. It's so far I'm at page 11. But each court was saying the court martial as it is set up, where you're not appointing persons properly, where they are not lawyers, where there is no independence, that court martial that you have there cannot try. But I'll just quote from some pages to exactly say what I understood the Supreme Court to say. The Honorable Chief Justice at page 126, 127 says, while there is no international treaty to which Uganda is a party, which contain an express provision providing trials of civilians by military courts, there is nonetheless international consensus that the jurisdiction of such courts needs to be restricted. That was what at page 134 he says, it is clear that international jurisprudence, even if the move is general to restrict civilians in military, the tribunals, the practice oscillates between complete abolition of civilians in trial courts and trial of civilians only in certain cases of an exception. He went on to say the trial of civilians by special court should be done only in exceptional circumstances. That is at page 136. At page 141 he says, I take cognizance of the crucial need for military courts for the maintenance of discipline. I also note, and which thereby ensures the defense of and security in Uganda. I also take note of the fact that there may be need to extend jurisdiction of military courts to cover civilians who fall within the few exceptions in application of the law as it obtains to other jurisdictions. At page 148, in conclusion, for the blanket trial of civilians, in conclusion, the provisions for the blanket trial of civilians, in the military courts, either as principles in 117H or as accomplices, does not satisfy the limitation requirements. The unconstitutional lies with the act of trying civilians in civilian courts under those provisions unconstitutional. So we need to read these provisions. We need to read the judgment of the court in extenso, in full, to understand what the court was saying. I'll go now to Honorable Justice